Good afternoon, everyone, and welcome to this FedSoc Forum webinar sponsored by the Administrative Law and Regulation Practice Group and the Regulatory Transparency Project, discussing independent agencies and the OIRA review process. My name is Libby Dickinson, and I'm an Assistant Director with the Federalist Society's Practice Groups and Networks. As a reminder, all opinions expressed are those of the speakers and not of the Federalist Society. In the interest of time, I will introduce our moderator, who will then briefly introduce our expert panelists. Our moderator today is Ellie Nachmani, associate at Covington and Burling. Ellie graduated magna cum laude from Harvard Law School and clerked for Judge Stephen J. Menashe of the U.S. Court of Appeals for the Second Circuit. If you'd like to know more about any of our speakers today, you can access their full, very impressive bios at fedsoc.org. That is fedsoc.org. One last note throughout the panel, if you have any questions for our speakers that pertain to the topic at hand, please submit them through Zoom's Q&A feature at the bottom of your screen, not the chat, so that we'll be able to access them when we get towards the close of our webinar. With that, I will hand things over to our moderator to start things off. Ellie, thank you so much for joining today and for moderating this excellent panel.
Excellent. Thank you so much, Libby. I appreciate it. And welcome to everybody listening. Thank you to the Federalist Society and the Regulatory Transparency Project for organizing this webinar, which is going to be about independent agencies and the OIRA review process, a question that really is front and center in our modern political and legal discourse. I'm pleased to introduce our panelists. We're going to hear first from my colleague, the Honorable Paul Ray. Paul served as Administrator of the White House Office of Information and Regulatory Affairs from 2019 through 2021. Before that, he served as Associate Administrator of OIRA, as Counselor to the U.S. Labor Secretary, and as a law clerk to Justice Samuel Alito. Today, Paul is of counsel at Covington and Burling LLP in Washington, D.C., where his practice focuses on administrative law and policy. Next, we'll hear from Kristen Hickman, who is the McKnight Presidential Professor in Law at the University of Minnesota Law School. Professor Hickman is a leading authority in the fields of tax administration, administrative law, and statutory interpretation. And from 2018 to 2019, she served as special advisor to the OIRA administrator. She co-authors the Administrative Law Treatise with Richard Pierce, as well as a textbook on federal administrative law with Pierce and Chris Walker. Then we'll hear from Roger Nober. Professor Nober is director of the George Washington University Regulatory Studies Center and professor of practice at the university's Trachtenberg School. His career includes service as executive vice president and chief legal officer at BNSF Railway, chairman of the U.S. Surface Transportation Board, and chief counsel of the Committee on Transportation and Infrastructure of the U.S. House of Representatives. Later in the hour, we will hear Q&A from the audience, so please make sure to submit through the chat box function, and I will turn it over to Paul now.
All right, well, thanks to Libby and everyone at FedSoc for putting together this panel, which I'm very excited to be a part of, and Ellie, thank you for moderating. So we're here to talk about OIRA review of independent agency rulemakings. So maybe we should start with about what OIRA is. Now, if you are viewing a panel on OIRA review of independent agency rulemakings, you probably already have some inkling of what OIRA is, but nevertheless, I'll give a very quick one-on-one for those who may not be familiar with the office. OIRA is a component of OMB. The acronym stands for the Office of Information and Regulatory Affairs. It was founded at the very end of the Carter administration, beginning of the Reagan administration, and it has several functions. It reviews agency requests for information collections, that is to say, federal forms. It is tasked with superintending the federal statistical system, federal privacy policy, and most importantly, and certainly most important for our purposes here, it conducts the interagency regulatory review process of the federal government. So I'm going to talk a little bit about how that review process works. When an agency wants to issue a regulation, it has to send that regulation to OIRA for review if the regulation is significant. Significant is a term of art. It means that the regulation has at least $100 million of effects per year, or it implicates several other bases for significance. It may implicate presidential priorities, raise novel legal or policy questions, or create a potential conflict between different agency initiatives. All of those facts would be bases for finding that a regulation is significant and needs to be reviewed by OIRA at either the proposed rule stage or the final rule stage. So for regulations that are significant, agencies must send them to OIRA for review before they can issue them. So when an agency sends a regulation to OIRA, OIRA itself gives the regulation a good scrub. It looks at the cost-benefit analysis, the agency's reasoning, if it's a final regulation, the way the agency has responded to public comments. And it also circulates the draft regulation among a group of agencies and White House offices who also review the regulation. OIRA will send the draft regulation to every agency or office that has what we say in the White House is an equity in the rulemaking. That is to say, some reason to care about the rulemaking. So to take an example, an HHS regulation about health insurance might go to the Department of Labor because DOL, through its administration of ERISA, has a lot to say about the provision of health insurance. It might go to Treasury to speak about the tax consequences of the regulation. It might go to the Department of Justice for legal review. They might go to the Domestic Policy Council and the White House Economic Council within the White House for their policy review as well. OIRA then takes its own thoughts and proposed edits to the regulation and combines them with those of the reviewing agencies and offices and sends them back to the author agency. And the author agency then has a choice. How is it to respond to these thoughts and proposed edits? Now, very often the agency either adjusts regulation in light of the comments and edits and is grateful for the helpful feedback, or it says we can't really accept this proposed change for X or Y reason, and the commenting agency lets it go. In some small portion of instances, the author agency feels strongly that it cannot accept a proposed edit, and the commenting agency or office feels very strongly that the agency must accept that edit. And when there is a disagreement of the sort I'm describing, OIRA runs what's called the elevation process, which is a process to resolve disputes between the author agency and commenting agencies. That process starts at the lowest political level and goes through successively higher political levels until resolution is achieved. Sometimes, in a very small number of cases, resolution cannot be achieved until you arrive at the Oval Office and let the president decide it. That happens very frequently, as you might imagine. As you should be able to tell already from this description of OIRA review, review serves several valuable functions. One is that it helps agencies to coordinate. It deconflicts agency priorities and helps agencies share views and expertise with each other. It leads to better analysis, including, but not limited to, cost-benefit analysis. OIRA, because it reviews hundreds of regulations per year, has a lot of expertise in the kinds of analysis that agencies use in rulemakings, and it can help agencies perform better analysis. And also just the knowledge that an agency has that eventually its analysis will be subject to review by OIRA incentivizes them to do better analysis in the first place. And third, OIRA review helps agencies understand presidential priorities. That's because presidential appointees at agencies and offices throughout the government get a chance to express their views about whether a regulation aligns with the president's views, and that can be very helpful to ensure that agencies are given the full benefit of the president's views. Okay, so that's by way of background. Now we're here to talk about OIRA review of independent agencies. We couldn't have had this conversation a year ago because a year ago OIRA didn't review independent agency rulemakings. The independent agencies were left out of Executive Order 12866, which is the Clinton executive order that OIRA review operates under. And they were also left out of the predecessor executive order from President Reagan, which served as the initial foundation for OIRA. I'm going to skip over the various reasons that the independent agencies were left out in the interest of time, and just note that for quite some time, most OIRA administrators have maintained across the aisle, across both parties, that OIRA review ought to extend to independent agencies because the independents would receive the same benefits of OIRA review as the core executive branch agencies do, and in particular the three benefits that I just mentioned. In 2019, there was an Office of Legal Counsel opinion opining that OIRA review of independent agency rulemakings, and in particular, presidential executive order directing such review would not violate the statutory guarantors of independence of these agencies. But nevertheless, the agencies remained outside OIRA review. That changed earlier this year with Executive Order 14215 by President Trump, which brought agencies, the independent agencies, into OIRA review for the first time. There's a very narrow exception for the Federal Reserve, and only in the conduct of monetary policy expressly covers the Federal Reserve in connection with its bank policy regulations, and it covers all other federal agencies as well in toto. So that's an exciting new development. EO 14215 also made other changes to the relationship between the White House and the independent agencies. I believe Roger's going to talk about those. So I will content myself just with unpacking what OIRA review of the independent agency rulemakings looks like under this new EO. We were approaching the 9-month mark of the EO, and so we actually have quite a bit of experience now with OIRA review of independent agency rulemakings, and so I'll sort of look to that experience to take stock of where things stand. So first, I'd like to talk about compliance. It's not a foregone conclusion the independent agencies would send their regulations through OIRA review. They might conceivably try to fight the order, right? Refuse to send their regulations to OIRA and wait for the president to do something about it. But with one important caveat, the independent agencies are, in fact, complying with the order. 6 agencies have submitted regulations for OIRA review: the FCC, CFPB, the SEC, the FDIC, FERC, and NERC. No independent agencies have publicly refused to comply with the order. No agency has stated that it will not send regulations to OIRA for review. Now for the caveat that I mentioned earlier, Federal Reserve's participation in OIRA review seems pretty lackluster to me. I mentioned earlier that EO 14215 covers the Fed, quote, in connection with its conduct and authorities directly related to the supervision and regulation of financial institutions. Nevertheless, when the Fed recently proposed or issued a proposed rule on methodology for financial institution stress tests, that, in my view, was pretty clearly significant and so should have come in to OIRA for review. OIRA, in fact, did not review the proposed regulation. And what's more, the regulation itself doesn't explain why that is. It doesn't say that OIRA waived review. It doesn't make a case that the regulation is not significant. Indeed, to read this Fed regulation, you need to know that OIRA existed. So that's pretty remarkable. On the other hand, back in July, the 3 banking agencies, so the Fed, the FDIC, and the OCC, which is part of Treasury, published a joint proposal modifying supplementary leverage ratio standards for global systemically important bank holding companies. And this rule was reviewed by OIRA. Now, OIRA's own online database lists the author agency that submitted it to OIRA as the OCC, not the Fed. But the records of a public meeting that OIRA held with stakeholders about the rule shows that officials from the Fed attended that meeting along with officials from the other 2 banking agencies. So the Fed is participating in the OIRA review process to some extent. What I'd say is that that participation is at best half-hearted, and we may see that position change one way or the other going forward, perhaps when Chair Powell's term as chair expires in May of next year. Next, I'd like to take up the timing of OIRA review. One of the main objections to OIRA review in general, historically, has been that it dramatically increases the time it takes agencies to issue proposed and final rules. Before the issuance of EO 14215, some worried that the review of independent agency rulemakings would be especially time-consuming, since after each OIRA passback, commissioners who need the independent agencies would have to negotiate among themselves about whether to accept OIRA's proposed edits. But after 9 months of OIRA review, it's clear that concerns about review clogging up the independent agency regulatory process were really overstated. OIRA review of these rulemakings has been really rapid. At this point, the average is about 17 days, which is, of course, a small fraction of the 90 days that EU 12866 gives OIRA to review regulations, and substantially less even than the 28 days for review of deregulatory rulemakings to which OIRA committed itself in a recent memo from Acting Administrator Jeff Clark. The average is about the same, even if we exclude reviews of CFPB rulemakings, which, because CFPB and OMB have the same head, we might think might go especially quickly. Finally, I want to talk a bit about how parties regulated by the independent agencies are adapting to OIRA review. As many of you know, I think, EU 12866 offers a chance to meet with OIRA about rules under review to all interested members of the public. Anyone can take advantage of this opportunity. All you have to do is go to reginfo.gov and request a meeting about a rule under review. And these meetings are actually pretty common. Many among the public do choose to meet with OIRA. It's not unusual on a rulemaking of consequence for OIRA to hold 10 or more meetings with the public. And these meetings can serve a very important role by educating OIRA about the issues implicated in a particular rule, pointing the office to helpful comments, etc. And these can ultimately significantly change rules under review. What's really remarkable to me then is that per OIRA's public records, it's only hosted 4 meetings about independent agency rulemakings since EU 14215 issued. There have been 2 meetings about a NERC rule, one about an FCC rule, and one about the joint rule by the banking regulators I mentioned earlier. Now, this is pretty surprising, and it suggests to me that parties regulated by the independent agencies really have not come to terms with OIRA review yet. They still don't know how to engage with OIRA, or even how important it is to engage with OIRA to make their case for changes to rules under review. So that's a quick overview of how OIRA review is working out with respect to the independence. And with that, I will pause and turn it over to Kristen.
Excellent. Thank you so much, Paul, and for that illuminating summary. Professor Hickman, floor is yours.
Thanks so much. So some of the things I'm going to talk about overlap with some of the things that Paul talked about. As was mentioned by Ellie, so I served as a special advisor to OIRA from 2018 to 2019 in a situation that was somewhat parallel to what's going on with independent agencies right now. For the first time, Treasury Department regulations, and particularly Treasury IRS regulations, were pulled into OIRA review in the first Trump administration, and I was on board to help with the implementation of that. Since then, a colleague of mine from Ohio State, Bridget Dooling, and I have taken a fair amount of time to try to study what happened, not just from being involved on the ground, but rather statistically and systematically with OIRA review of tax regulations. And we've gleaned some lessons from that, I think, that echo some of the things that Paul was talking about. First, let me emphasize here with respect to OIRA review and agency regulatory processes in general, that the mere act of agency regulation is an exercise of balancing, on the one hand, the efficiency and the benefits of tapping into subject matter expertise that come from Congress delegating policymaking responsibility to agencies instead of making all of the policies themselves. But on the other hand, we have to balance that against concerns about transparency and accountability and a relative lack of democratic legitimacy that comes from having agencies engaging in policy making through rulemaking rather than having Congress make those choices. And I think that a OIRA review is aimed substantially at transparency and accountability, that side of the equation, rather necessarily than being aimed at the efficiency or subject matter expertise side of the equation. Nevertheless, that doesn't mean that a OIRA review doesn't bring its own form of contributions to efficiency, as well as its own subject matter expertise, while facilitating and making more robust, I think, the transparency, accountability, and thus democratic legitimacy side of the equation. As Paul noted, one of the common complaints about OIRA review, I think, is, that it politicizes a rulemaking process. When we think about independent agencies, the whole key there is the word independence and the idea that they might somehow be insulated from political pressure when it comes to the rulemaking exercise. And one common complaint is the idea that bringing the White House in the form of a OIRA review into the equation necessarily will politicize a process that otherwise is left to technocratic experts at the different agencies with their subject matter expertise. As Bridget and I have studied what happened in the tax process, we push back on that narrative somewhat. First off, by recognizing that OIRA personnel have their own form of expertise that I think is incredibly useful in the rulemaking process. They are regulatory process experts. By working with lots of different agencies, they understand regulatory processes and how to make them more effective and more efficient, I think, in a way that individual subject matter experts who get bound up in their subject matter expertise, don't necessarily appreciate. Um, as a consequence, the interagency review process, for example, I think, when you think about rulemaking, so if an agency engages in a rulemaking process, they're obviously bringing their subject matter expertise to bear. The notice and comment rulemaking process that agencies engage in will bring in a variety of different perspectives. But one thing it doesn't necessarily do that OIRA is particularly good at facilitating is, the subject matter expertise often don't know what they don't know. And as Paul mentioned with interagency review, identifying other agencies whose whose jurisdictions or whose subject matters overlap in different ways with what a particular promulgating agency is trying to achieve. Identifying those agencies and pulling them in and seeking comments from those agencies often help to illuminate before regulations ever get posted if different agencies are acting at cross purposes with one another, or if there are considerations from overlapping policy making areas that haven't been taken into consideration by the promulgating agency. We see this in the tax context all the time because, of course, while on the one hand, Treasury and IRS officials are very focused on the tax system's revenue raising function, lots of tax regulations interact with environmental policy or healthcare policy or or pension administration and pension issues, as well as a variety of other subject matters, simply because of the array of tax deductions and tax exclusions and tax credits that are embedded in the Internal Revenue Code. And tax officials are experts at revenue raising, but they don't necessarily know everything there is to know about healthcare policy or environmental policy or food and drug policy or any of these other policy areas that overlap with tax administration. Independent agencies and the areas they regulate, it seems to me, are no different in that certainly the narrow subject matter expertise that the promulgating agency has is incredibly important to whatever it is the agency in question is trying to accomplish. But again, they don't know what they don't know in these overlapping areas that are outside the realm of their narrow subject matter expertise. And the OIRA interagency review process is great at identifying those sorts of issues. Now, think about this from the rulemaking perspective. Imagine you're a promulgating agency and you don't engage in that kind of interagency review, and you go ahead and you put out your regulation. Now, anybody who regulates knows that once a regulation is finalized, If you discover there's a problem with it and you need to amend the regulation or revoke part of the regulation or something like that in order to eliminate the problems that are created with some area of overlapping jurisdiction, you have to start over again and go through the whole notice and comment process from start to finish. It is substantially more efficient to identify these sorts of overlapping issues before you put the regulation out in the first place. We certainly saw this in the tax context. And, there's no question in my mind that we're going to see these sorts of things, these sorts of issues come up with the independents as well. Now, do you label that politicization? In that you are pulling in actors outside of the individual, the independent subject matter expertise of a single agency? Or do you simply talk about that in terms of comparative and complementary expertise? And I would suggest the latter is the more important frame for thinking about this. I will also say, Paul mentioned delay. One of the things that does frequently get talked about in the OIRA context is that rulemaking is delayed by OIRA review. Important regulations simply take longer to get out the door as a consequence of OIRA review. Similar to the statistics that Paul was mentioning with the independent agencies thus far, in studying an 8-year sample of tax regulations, one of the things that Bridget and I discovered was that on average, number one, OIRA was only reviewing about 25% of all tax regulations in the first place. So, that meant a lot of tax regulations didn't go through OIRA review at all. OIRA was just hitting the most significant ones. But separate and apart from that, even in reviewing those most significant regulations, on average, OIRA review took 33 days. Now, that's still some delay. It's a delay of about a month. But again, when you think of the efficiency gains of identifying issues before regulations are issued, rather than having to go back and go through the process again, if you discover that you failed to take something important into account with respect to overlapping jurisdiction, that 33 days starts to look like a bargain. Moreover, many, that's the average. Many regulations took a lot less time than the 33 days. In fact, we found some that took 2 days, 4 days, 5 days for OIRA review. Yes, there were outliers on the other end. There was one that took 131 days. That's a long time. But one of the things we discovered in our research of these tax regulations is oftentimes the ones that took the longest were the ones that tended to have either a very high degree of political salience, meaning a lot of people were really interested in them, and thus, again, it probably makes a lot of sense to spend more time kicking the tires, but also they were regulations that tended to have a lot of overlap with other agencies' subject matter expertise, suggesting that those other agencies were bringing in questions and concerns that hadn't been addressed in the first instance by the tax regulatory drafters. And again, I would suggest, to the extent that we want not just, if you're going to end up with regulations, you want the best quality regulations that you can get, that what we're doing here is we're improving the quality of those regulations. That's not to say that there's no delay. That's not to say that there's no politicization of the rulemaking process when you pull in the executive office of the president via OIRA. On the other hand, anyone who thinks that rulemaking is never political to begin with, I think isn't living in the real world of agency regulation. And, moreover, you have to sort of ask yourself, okay, if we're trying to balance efficiency and subject matter expertise with transparency and accountability and democratic legitimacy in rulemaking, it probably, on balance ends up that the interference and the perceived delay end up being more of a feature rather than a bug. And I think with that, I will turn it over to Roger.
Excellent. Thank you so much, Professor Hickman, for a really wonderful overview of the theoretical underpinnings there. Professor Nober, I'll turn it over to you.
Well, thank you, Ailey, and it's an honor to be on the panel with everyone. And I will try to blend my three separate perspectives as a regulator, as a regulated entity, and then as a scholar now studying regulation. And I'll probably conflate all three, and none of them will work very well, but I will try. And as somebody who, when I was in Congress, actually drafted the statute that created an independent agency, and then went on to head it, and then went on to be regulated by it. The first question, I think, that the discussion of what does OIRA review mean is really, what does it mean to be independent? And I think that's a question that folks would not have been asking until very recently. But what does it really mean to be an independent agency? And I think that there's a lot of different definitions of what is independent and what are not. The most common one that I think we all think of are multi-member, bipartisan, independent regulatory commissions that typically started out as economic regulators. So the Interstate Commerce Commission, the Federal Trade Commission, the Federal Energy Regulatory Commission, the Civil Aeronautics Board back in the day. And those were set up to be independent, originally they started in the 1880s, originally to provide expertise and to depoliticize rates and economics. And over time, that has really morphed into becoming, in instances like the Securities and Exchange Commission or the Federal Trade Commission, full-fledged 360-degree regulators. Now, there may be a lot of reasons for that, and when you're dealing with 140-year-old doctrines and agencies, it can sometimes not be that helpful to compare, say, the early 20th century with the Post-Administrative Procedure Act time. But what makes an agency independent? It's typically been multi-member boards that serve for terms of years. They're confirmed by the Senate and they serve for a term of years. I kid people that when I was confirmed by the Senate, I thought that was the first and only time in my life I ever had job security, but that may have been a false consciousness on my part. Just at least 20 years ago, I thought it was. And where the terms are staggered over time. And in most instances, not in every, but in most instances, the chair is appointed by the president. And so they're both apolitical and political at the same time, and in some ways can lag political change, because you could still have, up until recently, independent agencies with a majority of members of not of the president's party, of the prior president's party, until there's once somebody's term is up and they nominate and confirm a new board member and have a majority. So there can be some lag in effective control, even if the chairman can get designated as chairman by the president, stroke of a pen. There's a thing in the back there that's just a one line that says you're hereby designated as chairman. That's all it is. It's not even an executive order. It's just a designation. And so, the first question does OIRA review fundamentally change what it means for those kinds of independent agencies? And I think in some ways, yes, because typically when you're independent, you're decisionally independent, which means that the agency is not subject to the direct control of the White House, and normally the White House opining on or influencing the agency would be seen as a challenge to the independence and perhaps undoing what Congress had intended. But as a practical matter, I don't know how ironclad that was. As we've seen in recent years, chairs could be very, very political, and they could coordinate with the White House, even if not directly. And so I don't know that as time has gone on, simply having coordination with the White House would would render independence moot. I think that OIRA review, that now in the executive order that Paul mentioned earlier, there are several OMB oversights over independent agencies that are not just OIRA review of significant rules. And I'd like significant rules are certainly one thing. And, as a policy matter, if an independent agency is putting out a rule such as the non-compete clause or the greenhouse gas disclosure rule at the SEC. Those are really significant economic-wide rules, and having cost-benefit analysis applied to them and additional scrutiny as a policy matter, I think would be hard to argue with. If what it does is jeopardize the agency's overall independence, that's a different question. But just as, and to sort of draw on both what Paul and Professor Hickman said, as a matter of policy making, could the additional expertise and review and process added by going to OMB for really significant over $100 million rules, be a major policy problem? I have a hard time seeing that. But folks will argue that, and that is a legitimate question. But there are other parts of that executive order that also impact the way independent agencies operate. It provided that the chairman is to undergo an OMB performance review every year, that each agency had to have a White House liaison, which typically they didn't have, that the agencies would have to undergo a budget review, which again might seem axiomatic to most agencies, but many independent agency statutes provide that they will not have OMB oversight or White House oversight over their budget requests. And the Congress, when they put the statutes together, said, we want to hear directly from the agency at what their budget needs are. And then the one that as a former independent agency chair, I think is both the most interesting and the most significant is it puts a very interesting twist on the ability of agencies to litigate. Now, some agencies have what's called independent litigating authority, which means that they do not need to go to the Department of Justice and have the Department of Justice represent them in lawsuits. And that means that those agencies can choose to bring their own litigation and choose what they defend to litigate. Now, that has been controversial, and certain agencies have taken litigation positions and challenged transactions, for example, that folks would like to have seen that were controversial in their own right, but they were doing what the agency had the ability to do. The executive order, very interestingly, didn't challenge or directly contravene the statutory authority of agencies to have independent litigating authority. What it said is the chairman will not allow the agency to take a legal position that is different than what the attorney general or the president would want to see. And I may have the phrasing of that a little bit not perfectly, but so it's only coercive on the chair. Now, why do these issues on these different restrictions on the chair alone impact independence? Which is kind of an interesting question, because the chair is one vote on a multi-member commission and doesn't have the ability to him or herself vote anything in. What it does, though, is the chair has the power of scheduling. And so in theory, the accountability of the chair to OMB for the performance review through the White House liaison, through the coordination over the legal authority, would mean that the chair would not allow the agency to take a position that was contrary. So it's kind of a secondary effect on influence. And you might ask yourself, or I shouldn't say you, I have often asked myself, in a world where the chair can be designated at the stroke of a pen, is that how significant a difference is that really? Because most chair in the modern era are quite mindful of what the White House thinks and have been installed and designated as chair, not to take direct orders from the White House per se, but to implement policies that the White House and the chair believe would be supported by the president. And that I think is a common feeling among folks who are designated as chairs. So, that I think as a practical matter, OIRA review of significant rules is something that's been bipartisan. It's been considered for a very long time. And I don't think of all of the issues that are out there that are impacting the potential independence of independent agencies is the most significant of them. And you could argue would be good policy. And I think you would argue would be good policy. On the other hand, we haven't talked about the challenge to Humphrey's executor and the ability to hire and fire members, which would change this discussion significantly. And I think just an open question going forward is how will multi-member independent agencies operate in a world where they are really from a personnel standpoint, they are fundamentally cabinet agencies. So with that, I will stop and turn it over to whatever questions or any thoughts anyone else has. And thanks for having me.
Wonderful. And thank you so much for drawing on your wealth of experiences there and perspectives, Professor Nober. So my first question is for Paul. And Paul, we've been talking about how OIRA review might impact the independent agency and its rulemaking process. But I'm wondering, have you found that OIRA review of independent agency rulemakings actually enhances presidential influence over those rulemaking? And, take us maybe through the White House side of that discussion.
Yeah, sure. So the main way, OIRA is itself within the White House, right? So there probably is, the OIRA administrator probably has a slightly better sense of the president's priorities than, say, someone at an equivalent level of seniority at one of the agencies, just by merit of being in OMB, which is part of the White House. So there's that, but I think OIRA's the main way of channeling presidential priorities into the regulatory process is that it allows political appointees across the executive branch, each of whom have a slightly different perspective on the president's priorities, to all speak into the regulatory process and help each other calibrate a regulatory policy that more closely aligns with the way the president thinks about the world. So, let's say that Cabinet Secretary X wants to issue a regulation, which he, plausibly alleges is consistent in some way with the president's priorities, but Cabinet Secretary Y and White House official Z have different views, and they object in the regulatory process. Well, the elevation process then allows officials representing all these competing views about how the president, thinks about the world to set their views in juxtaposition to each other and talk it out, right? And I found that as the elevation process goes forward, you pull in officials who are more and more senior, and therefore generally, not without exception, but generally have a more and more accurate and comprehensive view of the president's priorities. By the time you get to the cabinet, which is the elevation, some of the elevation process before you go to the Oval Office, cabinet secretaries tend to have a pretty good sense of where the president's head is on issues that affect their portfolio. They also, mindful that the next stop is the resolute desk, are pretty careful not to take out positions that they think the president wouldn't agree with, right? No one likes to go to the president and say, I maintain this position that in retrospect, I think you probably don't like, sir, right? So I find that as the elevation process goes forward, the position that officials arrive at approximates the president's more and more. And then, of course, there is the ultimate stop with the president if there is intractable disagreement among agency heads. So I think that's the elevation process is the principal way through which OIRA review helps bring regulations more into alignment with the president's priorities.
Excellent. Professor Hickman, my next question is for you. And of course, there are a ton of agencies across the government that issue regulations of deep consequence on issues from healthcare to labor to the environment and on that are well known to be political agencies subject to presidential control. There's, of course, a lot been made about the virtues of independent agencies, and you talked a little bit about this empirical question of whether OIRA review actually politicizes the process. But I sort of wonder, why is politicization so bad in, these certain discrete areas when it seems to be generally accepted in other areas of deep consequence that political rulemaking may well occur? And for some of these independent agencies, their members in recent years have been quite political themselves.
Well, so I think this whole idea of independence to some extent, I mentioned it a little bit and Roger did as well. When we came up with the idea of independent agencies in the first place, back in 1887, and then a number of them were created during the New Deal era, there really was this perception, particularly as Roger suggested, with respect to economic regulation in the form of rate making for common carriers, railroads, telephones, electric companies, things like that. Um, that rather, and in an era when we didn't have, a robust civil service necessarily in a lot of agencies, um, there was this idea that rather than having these, very important economic matters, being left to patronage appointees, who with their obvious partisan ideas and perhaps lacking relevant subject matter expertise, at least relatively speaking, that by creating independent agencies staffed with subject matter experts, that they would regulate in the public interest, utilizing, through technocratic expertise in a way that would yield better quality regulations, less politicized regulations in the sense of, more based on technocratic expertise rather than pure partisan politics. If that is how everything had stayed, maybe there might be a point to it. But, I think we've long since come to recognize that the idea that we can wall off subject matter experts from politics was not entirely realistic, that politics was always going to enter into the process. Um, I also think that, again, whereas once upon a time in government, maybe these different, you know, pockets of economic rate making, maybe they were really truly walled off from one another in terms of not having a lot of subject matter overlap. I think that that subject matter overlap between independent agencies and non-independent or regular historic, traditional executive branch agencies, that's grown a lot. The idea that these are isolated pockets of regulation that don't overlap with one another, really isn't what we have these days. Furthermore, when you think about uh, the kinds of the broad delegations of policymaking discretion extended to agency officials, um, and the expansive realm of agency rulemaking that has emerged, since the 1960s in particular, the 1960s, the 1970s, the 1980s, we saw a dramatic rise in rulemaking by agencies on a whole range of different areas of public policy. Um, it seems to me that the idea that somehow technocratic expertise is going to have neutral, apolitical answers to a lot of the policy questions that are currently addressed through rulemaking, um, just isn't terribly realistic in 2025. If it was ever realistic, even in 1887, it certainly isn't realistic today. So I think today we could look at this and say that some amount, these are political decisions that are being made. They aren't purely neutral, technocratic decisions that are being made by agency subject matter experts. These are political decisions, particularly in the realm of significant regulations, which are the ones that OIRA reviews. Maybe there are some small, narrow, gosh knows in the tax context, we've got a lot of small, narrow, technical regulations that get adopted every day that just make everyone's life easier in terms of understanding what the tax code means and how it's supposed to be implemented and how the IRS is going to implement and administer it, that don't go through OIRA review and don't need to go through OIRA review. But it's the really big, significant regulations that carry huge political salience, no matter who's doing the decision making. So at that point, I'm not so sure that, I think a part of the reason, politicization has a negative connotation to it. But, I think Bridget and I have argued, at least in the tax context, these regulations are political anyway. The idea that they're somehow more political because of a OIRA review just denies reality. So at that point, I think, it really ought to be more a question about how do we leverage the subject matter expertise across the executive branch, including the independent agencies, to yield better regulations that are more responsive to, democratic concerns and the electorate's policy preferences, rather than trying to kid ourselves into thinking, at least on the rulemaking side, that somehow we are achieving something unique through labeling the agencies that are doing the promulgating as being independent.
Yeah, I'd like to bring Professor Nober into this conversation because Professor Hickman takes us back to 1887, of course, the Interstate Commerce Commission. It seems that originally a lot of these independent regulatory commissions were thought of in more of the tribunal or adjudicatory model. Now, of course, we've moved toward rulemaking, but I wonder if the fact that the origins of the justification for the independent regulatory commission model were adjudicatory in nature, does that give us a little less heartburn about subjecting at least the rulemaking function of the independent agencies to the OIRA review process?
I actually think that's a really important point, which is these agencies were set up as adjudicatory bodies, which were functionally expert courts, if you will, with many of the procedural requirements and protections that you would have in a court case. Chief among them, ex parte communications, hearings on the record, written decisions, so that they were somewhat clear, and they were meant to mimic judicial decisions, and it's where formal adjudication began and originated from. As time has gone on with the Administrative Procedure Act, things have changed some, and there are different standards today for how agencies would handle, from a procedural standpoint, rulemakings of general applicability and adjudications of specific and coercive applicability on individual parties. Now, there are a lot of differences to them, the most important being that rulemakings are only prospective and adjudications can be retrospective. But in the agencies today, many of which do hundreds of adjudications a year and only a handful of rulemakings, for example, in a rulemaking, you can do an ex parte communication. Members can discuss it. You have to note in the record that there was an ex parte communication, but the rulemaking for an adjudicatory agency works exactly the same that it does for a cabinet agency. In an adjudication, you would never ex parte communications are prohibited out of pocket, and there typically is a decisional line between perhaps the hearing officer, the administrative law judge, and then the members. And so the formal restrictions between the two are different. So I'm less troubled, and I think you're absolutely right to say that rulemakings of general applicability, which are general prospective policies, implicate different administrative law questions and needs for protection. And so I do think that they are less significant, and the need for pure independence is less significant. Now, to just follow on to a point Professor Hickman raised, what is the impact of political influence? Now, if it's on a major rule, like should there be non-compete clauses nationwide, which many of us may have views on, but hearing nationwide stakeholders opine on that, and even having the ability to talk to the White House, I don't think jeopardizes, in fact, you could argue improves the quality of the final rule when it ultimately comes out by having more process and more ability and more different views to look at it. And following on what Paul said earlier, the people in the White House are going to have a broader view of what the president might think of an important national policy like that than perhaps an individual agency senior level SES member might. At the same time, how do we feel about politics entering into adjudications where if there's a rate dispute and one is a giver to the White House and goes in and makes and says for political reasons just order them to fine for me, that would raise more sort of appearance concerns, and I think we would have I would have more concerns with the ability to influence adjudications as opposed to a prospective rulemaking of general applicability. So I do think that there's still an important place for independence in the adjudicatory function.
Excellent. We have just a few minutes left and a couple of audience questions. So let's try to see if we can do a lightning round here. Paul, one audience member asks if you could give examples of OIRA affecting a regulation, maybe a fun story or something along those lines of how OIRA actually impacts that process.
Yeah, sure. Here's an example. I can't say which regulation it's about because that would violate executive confidentiality. But I remember a rule in which one agency thought it was very important to do something that would have helped farmers a lot, and one thought it was really important to do something that would have helped refiners a lot. It was about the issue was ethanol. I can't say the regulation again, but these agencies just disagreed at the very top, right? Their heads disagreed about what should be done, and so the rule went to the president for resolution, right? It went all the way up through the OIRA process, and eventually the president struck a balance, right? So that's an example of a rule where OIRA is instrumental in sort of shepherding a conflict from the lowest levels up to the highest. Here's an example. I can actually mention the rule because it's public, though it wasn't for my tenure. In the Obama administration, EPA proposed to issue a regulation that would have dramatically regulated the production of ash, and OIRA thought it was going to be very, very costly. Here too, OIRA shepherded the dispute all the way to the very top. The rule went to the president for decision, and the president decided to forbid EPA to go forward with the rule. So OIRA issued a return letter, and EPA was not permitted to proceed. So yeah, there are these are dramatic examples, but in dozens or more of important regulations per year, OIRA makes small changes that make the regulation better.
Excellent. I see we are just about at time, so I think we will end it here. We could go on probably for another hour about independent agencies and OIRA review, but with that, thank you again to the Federalist Society and to RTP for organizing this wonderful conversation, and thank you to our discussants for some really interesting perspectives on how OIRA review impacts the independent agency process.
Awesome. Thank you so much to all of our speakers for joining us today, for sharing your insights. Thank you, Ellie, for moderating. If our audience is interested in learning more about all of our programming here at the Federalist Society, please visit our website. Again, that's fedsoc.org, or feel free to send us your feedback. We always love to hear it at fedsocforums@fedsoc.org. Thank you and have a great afternoon.